Hello friends, welcome to iExamB's Law Channel Legal Week. We have started 300 most important law question series, and in this video we are going to discuss the part 5, which will consist of questions from Code of Civil Procedure. I have already shared the schedule with you. On 21st of October we are going to discuss questions on Code of Civil Procedure. On 28th of October we are going to discuss questions from IRDA and PFRDA. These are specially for PFRD legal exam, for which phase 1 is on 5th of November. I hope you are finding this series useful. Starting with the first question of this video. An executing court can. The correct answer is neither modify nor vary the terms of a decree. An executing court can only execute the decree, neither modify nor vary the terms of the decree. As a general rule, the territorial jurisdiction is the condition precedent to the court executing a decree, and therefore no court can execute a decree in respect of property situated entirely outside its local jurisdiction. An executing court cannot go behind the decree. It must take the decree as it stands and execute it according to its terms. It has no power to vary or modify the terms. It has no power to question its legality or correctness even. This is based on the principle that a proceeding to enforce a judgment is collateral to the judgment, and therefore no inquiry into its regularity or correctness can be permitted in such a proceeding. Moving to question 2. When the court rejects an application for review under CPC, such order is. The correct answer is not appealable. When an application for review is being rejected, it is not appealable. This is given under Order 47 Review. Rule 7 talks about order of rejection not appealable. Question 3. An executing court cannot determine the questions relating to which of the following. The correct answer is modification of decree. This is given under section 47. Questions to be determined by the court executing decree. All the questions arising between the parties to a suit in which the decree was passed or their representatives and relating to execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by the separate suit. However, modification cannot be done by an executing court. Moving to next question. A civil court cannot issue commissions in which of the following cases? The correct answer is to execute a decree. This is given under section number 75, power of court to issue commissions. Commissions can be issued to examine any person, to make a local investigation, to examine or adjust accounts, to make a partition, to hold a scientific, technical or expert investigation, to conduct sale of property which is subject to speedy and natural decay and which is in the custody of the court pending the determination of the suit, and to perform any ministerial act. Question number 5. As provided under section 79 of CPC, a suit by central government must be filed in the name of. The correct answer is Union of India. Section 79, suits by or against the government. In a suit by or against the government, the authority to be named as plaintiff or defendant as the case may be shall be, in case of a suit by or against central government, the Union of India, and in state government, the state. Question number 6. In how much time respondent may file cross objections from the day of service of notice of hearing of appeal? The correct answer is in 1 month. This is given under Order 41, appeals from original decrees. Rule 22 deals with this. Upon hearing, respondent may object to decree as if he had preferred separate appeal. Any respondent, though may not have appealed from any part of the decree, may not only support the decree but may also state that the findings against him in the court below in respect of any issue ought to have been in his favor, and may also take any cross objections to the decree which he could have taken by way of appeal, provided he has filed such objection in the appellate court within 1 month from the date of service on him or his pleader of notice of the day fixed for hearing of the appeal, or within such further time as the appellate court may see fit to allow. Question number 7. Judgment under section 2 subsection 9 of CPC means. Judgment means statement of grounds of an order or decree. Section 2 subsection 9 of CPC defines the judgment. Moving to question 8. Mesne profit means. The correct answer is profits received or could have been received by a person in wrongful possession of property and interest received on such profits. This is given under section 2 subsection 12 of CPC, which talks about mesne profits. Mesne profits of any property means those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest on such profits, but shall not include profits due to improvements made by a person in wrongful possession. So improvements are not a part of mesne profits. Moving to question 9. Under CPC, the court shall have jurisdiction to try all suits of civil nature accepting suits of which their cognizance is. The correct answer is either expressly or impliedly barred. This is given under section 9 of CPC, courts to try all suits unless barred. Question number 10. No suit against the government or public officers shall be instituted until the expiration of dash period. Next, after notice in writing has been delivered. The correct answer is 2 months. So, a suit can be initiated against a government or public officer after the expiration of 2 months after the notice has been served. This is given under section number 18, notice. Question number 11. Interpleader suit is a suit. The correct answer is instituted by a person who has no interest in the subject matter. An interpleader suit is one in which the real controversy or dispute is not between the plaintiff and the defendant, but is rather between the defendants only, who interplead against each other. The hallmark of an interpleader suit is the fact that in an interpleader suit, the plaintiff is not really interested in the subject matter of the suit. Section 88 of CPC deals with interpleader suits and where interpleader suits may be instituted where two or more persons claim adversely to one another the same debt, sum of money or other property, movable or immovable, from another person who claims no interest therein other than for charges or costs and who is ready to pay or deliver it to the rightful claimant. Such other person may institute a suit of interpleader suit against all the claimants for the purpose of obtaining a decision as to the person to whom the payment or delivery shall be made and of obtaining indemnity for himself. So, for example, there is a piece of land for which rent is due. A says, I am the actual owner of the land. B says, I am the actual owner of the land and I deserve the rent. Now, C is a person who has to give rent and he just have to get over with his debt. Here, A and B can enter into an interpleader suit with respect to the ownership of this land, and whoever wins that suit, C will pay the debt amount to that particular person. So here C really does not have any interest in the subject matter. Moving to question 12. X is living in Delhi and Y his brother in Mumbai. X wants to file a suit for partition of their joint property situated in Chennai and Bangalore. Where can the suit be filed? The correct answer is the suit may be instituted either in Chennai or Bangalore. This is given under section number 17 of CPC, suits for immovable property situated within jurisdiction of different courts. Where a suit is to obtain relief respecting or compensation for wrong to any immovable properties situated within the jurisdiction of different courts. The suit may be instituted in any court within the local limits of whose jurisdiction any portion of the property is situated. Moving to question 13. In case of public nuisance, a suit for declaration and injunction may be instituted by. The correct answer is two or more persons with leave of the court. This is given under section number 91 of CPC, public nuisance and other wrongful acts affecting the public, and who may institute these suits, either the Advocate General or with the leave of the court, two or more persons. Question 14. Where does second appeal lie under section 100 of the CPC? The correct answer is High Court. This is given section 100 second appeal, save as otherwise expressly provided in the body of this code or by any other law for the time being in force. An appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court if the High Court is satisfied that the case involves a substantial question of law. Question number 15. Objection to the place of suing can be allowed to be taken. The correct answer is only at the first opportunity in the trial court. This is given under section number 21 of CPC, objections to jurisdiction. Question number 16. When can an appeal lie to the Supreme Court under section 109 of CPC? Option 1. When the High Court certifies that the case involves a substantial question of law of general importance. Option 2. When the High Court certifies that the said question needs to be decided by the Supreme Court. Third, when the Supreme Court feels that any issue has not been determined by the High Court. The correct answer is both 1 and 2. In section 109 of CPC, when appeals lie to the Supreme Court, subject to the provisions in chapter 4 of part 5 of the Constitution and such rules as may from time to time apply, an appeal shall lie to the Supreme Court from any judgment, decree or final order in a civil proceeding of High Court if the High Court certifies that the case involves a substantial question of law of general importance and that in the opinion of High Court, the said question needs to be decided by the Supreme Court. Moving to question 17, interlocutory orders are issued by the Civil Court. The correct answer is during pendency of civil proceedings. Order 39 talks about temporary injunctions and interlocutory orders. Rule 6 to Rule 10 deals with these. Interlocutory orders are also somewhat similar to temporary injunctions. Interlocutory orders only settles intervening matters relating to the cause. Such orders are made to secure some end and purpose necessary and essential to the progress of case and generally collateral to the issues to be settled by the court in the final judgment. These orders are also of different natures, such as interim sale. Interim sale of any movable property may be ordered if it is subject to natural decay, for example, vegetables. Next can be detention, preservation, inspection, etc. of the subject matter of the suit. Moving to question 18. Period of retention in civil imprisonment as a consequence of disobedience or breach of any injunction shall not exceed. The correct answer is 3 months. This is given under Order 39 Rule 2A, consequence of disobedience or breach of injunction. Here, civil prison can be for a term not exceeding 3 months. Moving to question 19. Amendment in a pleading shall be effective from, the correct answer is from the date of application of the amendment. Order 6 Rule 17 talks about amendment of pleadings. Moving to question 20, last question of this video. A and B sue C for recovery of ₹1,000. C has a debt due to him by A alone. Here C can. The correct answer is C cannot set off a debt due to him by A alone. This is given under Order 8 Rule 6 of CPC and this is actually an illustration from that rule. So these were the set of questions from Code of Civil Procedure. I hope you had a good revision. Let's meet next Friday with questions on IRDA and PFRDA and later on 4th of November with questions from Law of Evidence. Subscribe to our LegalView YouTube channel. This is your one-stop solution for all legal exams. If you have any queries or suggestions, you can write them down in the comment below. You can also call us on this number. iExamB helps you unfold your potential and prepare for the exam 50% faster. Thank you.